magistrate hearings, starting at 2 o'clock. And if the clerk would read the announcements, please.
The purpose and function of the Jacksonville Beach Special Magistrate Hearing, in accordance with Florida Statutes Chapter 162 and the City of Jacksonville Beach Code of Ordinances, is to reach an equitable expedition to enforce the codes. The city presents the violation and evidence to the special magistrate. Next, the property owner is sworn in and responds to the violation and evidence. Both the city and the property owner may call witnesses to provide sworn testimony relevant to the case. This is a quasi-judicial hearing, not a public forum. Individuals not called as sworn witnesses will not be heard.
Thank you very much. So I see we have 3 cases.
Yes, Your Honor.
Are all of those still to be heard today?
Yes, and it looks like we have present today T. Gregory. Yes. Mr. Thomas. Okay. So Joseph Benza, we can move him to the last since he's not present. We'll go ahead and do the ones that are present.
Okay, that's fine. Could we start with Mr. Thomas?
Yes.
Excuse me. I'm not ready to- I apologize.
We'll go ahead and swear in speakers. We'll swear in her first, and then we'll swear in you. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name and position.
J.G. Beavers, City of Jacksonville Beach Code Enforcement.
Thank you.
Okay. Yes, this is, case 2373, property owner Samuel Thomas. Violation address is 108 South 11th Street, Jacksonville Beach, Florida, 32250. Violations was accumulation of trash, litter, and debris. Any condition that provides harborage of rats, mice, snakes, and other vermin. And it's section 27.1, which is having a commercial dumpster in a residential zone. As you can see, this was the dumpster with the different items, trash and debris throughout the dumpster. This is on a vacant lot. I did do a final inspection and the violation has been complied.
Is there still a commercial, what is the receptacle on the left?
Those are vehicles on the left.
Oh, okay.
Yeah,
I'm
and
sorry.
that's
I just couldn't quite see.
yeah, in the middle you'll see a trailer that is a lawnmower.
Okay.
Is it 0 turn or something? Okay, that's
Okay.
it on there. But the commercial dumpster has been removed.
Okay, great. What about the accumulation of trash and?
That was included in the
That's done
dumpster.
correctly?
Yes.
Okay. Before we get to your, well, could you give us your recommendation, please?
The city recommends that this case be closed.
Okay. Mr. Thomas, do you want to say anything?
Yes.
Okay, we'll go ahead and swear you in now. You can raise your right hand. Do you swear or affirm that the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God? Please state your name and address.
Samuel Thomas, my address is 2249 South Beach Parkway, Jacksonville Beach, Florida, 32250. So, one thing I have to say is, I didn't know that the reason why we had a dumpster there is simply this. We had trash and stuff on the side of the road. It's been there for a while. We had trash on the road. The city would not come out and didn't come out and pick it up. So we got a dumpster, put it in there, and we just kept accumulating the trash. We had problem after problem. We did have a guy to come remove the dumpster. I didn't know that he had a certain size dumpster on my vacant property. And I own that whole block in there, so I didn't know that I was violating some kind of rule or anything like that. My goal is to try to keep that section of our neighborhood clean. And we put a dumpster there trying to get that, we get the dumpster moved. But now I know that you can't have a dumpster, so in the future, what I'm gonna do, and I hate to do it, I'm just gonna pile trash on the side of the road, and whenever the city feel like it's time for them to come pick it up, then they apparently will. Since then, they have pile stuff on the side of the road, and they still hadn't come. I called downtown, see if they come pick it up, they won't pick it up yet, so I don't know what to do.
Thank you very much. Is there a smaller size dumpster that is allowable?
Not in a residential area. One thing I do want to include, when you have a vacant lot, and the way this vacant lot sits is between two main structures, two other properties.
Which are now,
Yes, and technically you're not allowed to store like the vehicles, but the way the property sits, it's almost like they're on the side of the house, that's your mother's house that's on the left-hand side?
so one
Yes.
on the left, mine's on the right.
Okay, so, when I initially cited this, I thought it was all one property. And then when I did talk to Mr. Thomas, and then I looked on Jack's GIS, you can see that it's actually a separate lot. So that kind of changes things that what you can and cannot store on the vacant lot. Like I said, the cars are parked there, but most of the cars appear to be tenants of the houses where the structures are.
So are you saying that if it was not a vacant lot, it could be, this would not be a violation?
If it,
With the dumpster?
correct.
Anyway.
No, not as far as the dumpster. The commercial dumpster, only time you can have a commercial dumpster in a residential zone is if you have an active work permit. So if there is construction going on, those type of things, that's when a commercial dumpster is allowed. But
And
not in a residential area, no.
Okay. What was the distinction that the vacant lot made then?
The actual dumpster,
No, you said that it changed things when you realized it was a vacant lot.
because, no, I was just saying, the stuff that's being stored
Oh,
on the
okay.
vacant lot, as far as the vehicles and the trailer and all that stuff. But I decided for the actual dumpster.
Okay. Well, is there, can you direct Mr. Thomas to anybody in particular who can assure that when there is trash to be picked up in the area?
Well, Mr. Thomas is retired from the city of Jacksonville Beach, so he's familiar, like he stated, that when he does put items out on the side of the road, there are bulk pickup days, that's scheduled for each, area. So he can put those items out and they'll be picked up. He can also always contact Public Works.
Okay, so perhaps, Mr. Thomas, if you can remember when the bulk pickup days are,
Understand.
then it wouldn't have to stay.
Yeah, I
We very much
understand.
appreciate, and
I understand.
thank you for being here today,
Okay,
and,
good, no problem. Thank you very much.
thank you.
Okay?
So that case is closed.
We're
So,
closed, yes.
I'll just, do an order that basically just says it was
Closed,
closed.
okay.
I believe Mr. Benson may have shown.
Mr. Benson, are you?
No, I'm just here to watch.
Oh, okay, okay,
Sorry.
All right, so we're gonna move back to, A
Yes.
on the agenda, which is, case number 23130, 1121 North Third Street, Incorporated. Property address is at 1121 North Third Street. This was in regards to, commercial merchandise being displayed outside.
Correct. So it's,
So this is wrong. As I'm looking at it,
right,
this is wrong. It should have been the section 34342, which is also listed on the notice of hearing. I did not catch that I had put the wrong, section on the PowerPoint, but the section is 34342B, C, and D, permitted accessory and conditional uses, the use of outside sales and display of merchandise, which is not a listed use in the C1 zoning district. And also section 34-3116 of the Land Development Code that states the exclusivity of the uses in zoning districts The permitted uses and conditional uses in the zoning districts established in Article 7 zoning districts are exclusive and shall be permitted subject to the standards and procedures of the Land Development Code. So, in short, the outdoor display and sales of merchandise is not permitted in Jacksonville Beach.
Okay, and, I know that okay, actually, I'm not sure, were you finished?
Yes.
Okay, and could you tell us what this is from
This is-
2023?
Yes, so the case was initially cited for the outside display of sales and merchandise from T. Gregory Imports. As you can see, merchandise is being set outside. Also, items were being placed in the parking lot. This was an A-frame sign that was set outside. The business is not located in the central business district, and that was where the A-frame sign was also an issue, because they're not located, it's only in the central business district.
But what we're,
Reject
but-
hearsay on her testimony regarding the state of the law and such.
excuse me,
I'm sorry, I didn't interrupt you, I was just raising an objection. I apologize for the interruption, but I'm raising an objection.
I'm sorry, go ahead.
you can object when you can object to everything that you want to object to when you're at the podium and after you've been sworn in.
You don't want me to raise objections as the evidence is presented?
Excuse me?
And I'm asking, it's my understanding that she's presenting evidence, and if she presents evidence that is subject to objection, it's my understanding that she raised an objection at that time, or you said
No.
we should preserve objections?
Yes,
Okay.
that's what I asked. You can speak after you've been sworn in, and you can bring any objections at that time. You're not even in front of microphone, so, and this has to be recorded. And we're not in a court of law. We're in a special magistrate hearing that has different, slightly different rules. It's not necessary that you stand up and object at the moment that the person says something, okay? Thank you. Okay. So, have you been, Ms. Beavers, have you been, I can't quite read what it is that you're showing me.
Oh, on these pictures, this was just showing, the A-frame sign that was out front of the door on the right-hand side. And then, on the other pictures, it was just showing the merchandise that was outside in the parking lot and around the front door entrance area.
And so the merchandise was outside near the front door
And in the parking lot,
and in their parking lot?
correct.
Okay, can you tell me the dates of those pictures?
The case started September 21st of 2023, and over the year, several pictures have been taken, but because this was a continuance, I didn't include all the pictures from each one, but the ones that I'm showing today, are from May 2nd, and then June 25th and June 7th.
And are there any more recent ones? Are the most recent ones the June?
The June 25th, there was no change, even when I did a follow-up inspection, there was no change, so, they have been in compliance since our last hearing.
They've been what?
In compliance?
They've been in compliance since June 26th?
Yes.
And then what would be your recommendation then at this time?
My recommendation, would be that they remain in compliance with the city ordinance, that there is no outside display or sales of merchandise. And also with the A-frame sign or any other signage, they would have to apply for a sign permit because they are not located in the central business district.
However, I don't see that there's been a notice of violation regarding that A-frame sign.
There was a notice of violation of the A-frame sign that was separate. That was not included in the special magistrate because they had complied, they had removed it. So it was never included, but they were cited for it.
But there's been no hearing.
There has not been no hearing on the sign.
Okay, then I'm not gonna rule on the
Okay,
A-frame sign.
that's fine.
Could you tell me, just for my information, what was the date of the notice of violation for the A-frame sign?
I don't have that in front of me right now.
Can you tell me approximately?
It would have been close to the May 22nd, the day that I took this picture.
Okay. So I'm gonna just say approximately May, June. Would that be? Okay, so we're back just to the one, violation, section 34-3042, B, C, and D, because the outside sales and display of merchandise is not a permitted use in any of those,
In section 34 to 31:16.
right, but that is the 342 is, just for clarity, the commercial limited C1 zoning district, is that correct?
Correct. (34-3116) outlines what's allowed. Yes.
Correct. Okay, is there anything else you would like to add at this time?
None at this time.
Okay, thank you. Mr. Powell? If you'll give, your name and address and, that, you know, that you're here on behalf of T. Gregory and also your company, the LLC, and then, you can be sworn in.
Thank you. My name is Matthew Patrick Coe. I am here on behalf of T. Gregory Imports, which is the business name of the business that is operating at the subject address, and that business is owned by Pink Moon Imports LLC. I believe we're at the evidence introductory stage, so I guess it's time to ask the question.
Oh, go ahead and
Is that
swear you
And
in.
if you could
Swear in.
move, if you could please also move the mic,
Is
because
this better?
you're really coming in and out.
Is this better?
I think so.
Thank you.
Please raise your right hand. Do you swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your name and address.
Matthew Patrick Coe, and I am an owner-member of Pink Moon Imports LLC, which is the corporate entity that owns T. Gregory Imports, the business that operates at the subject property. May I ask
Thank you very much.
questions, Ms. Beavers?
Well, you can
Oh,
proceed
sorry.
in any manner that you wish.
Thank you. I guess I'll give a very brief procedural posture. This is the third time that we're at this hearing, or at a hearing, related to the underlying issues and alleged violations. The first time was in May, and we argued, and that was based on an alleged violation of the prohibition against the business of outdoor advertising. We argued that that statute was not applicable and that the city had not shown any violation of that ordinance. That hearing was continued, and the city was instructed to bring a witness to explain how ordinance was violated. The city's witness at the second hearing acknowledged that that ordinance was not applicable and instead pivoted to argue that there had been a violation of a different ordinance, 34.2 B, C, and D. So over objection, the court allowed the city to drop essentially the initial alleged violation, amend and add the new alleged violation, and set a new hearing, which is what we're here for today. So this is the third hearing in that context.
And if I may, it was consented to by you that if the city issued an amended notice of violation by a certain date, which I believe was July 11th, then let me confirm that. Actually, it was no later than July the 17th that you stated that that amount of notice would give you adequate time to prepare for the hearing today.
With all due respect, and I don't have the record exactly in front of me. My recollection is you asked if I would have adequate time to prepare, and I said essentially that I expected I would, but I did not know what they were going to present or whether I would actually have adequate time to prepare. But I'm not saying at this time that I don't have adequate time to prepare. I'm saying that I objected at that time to allowing the city to amend and put forth a whole new basis of violation at that time. That was what was objected to, and that the court allowed it. And I'm just stating that as part of the procedural posture. So we're now here on a hearing where the city.
The order itself states that you and Ms. Beavers both agreed that if an amended notice of hearing was issued within 21 days from June the 26th, then the hearing in this matter could be continued to September 25th, 2024, which would give Mr. Poe adequate time to prepare. And that was a specific question on my part because I wanted to be sure that you had adequate time to prepare. And so we discussed that very issue.
Well, and I appreciate that, and I'm not arguing that I didn't have adequate time to prepare following receiving the amended notice. I'm just stating that I had objected to them being allowed to amend the notice, because I don't think that was proper. And I'm not saying that I did not have adequate time to prepare for today. I'm not making that argument one way or the other. I'm saying that I objected to the amendment in the first place. But anyway, that's a matter of the procedural posture. We are now here on an alleged violation of 342 B, C, and D. And I believe the city has just presented their evidence. And I think sort of next, and she said she has no further evidence to present at this time. If the city is rested on presenting their evidence, actually, I would like to ask a couple questions about the evidence.
She has the right to, in my opinion, she has the right to rebut your testimony. So if something does come up that she has not addressed, I think that I would certainly allow her to testify in regards to anything that you raise.
Procedurally, is it appropriate now for me to ask Ms. Weaver some questions about the evidence she presented?
Is it proper for you to do what?
To ask Ms. Beavers about the evidence that she presented.
Yes, you can ask questions.
Has Ms. Beavers been sworn in?
Yeah,
If you were sworn before, I don't know that you were, I didn't listen. Or you were probably sworn in as part of the prior proceeding that happened just before this one. If she was, then I take it that she was. You put a few pictures up there of that were each of the pictures that you shown taken by you personally?
Yes.
Can you go back to the first picture and we'll go through each one of them one at a time, please? September 23. This is prior to the violations that we're talking about here. Is this sort of for background information to show that you believe there had been a previous violation that had been dealt with a prior order? Is that what this one's related to? It's dated September 21, 2023, marked Exhibit A.
The property had previously been cited for outdoor display. And in that order, it was stated that if the violation occurred again, that it would be brought back to the special magistrate for a fine up to $250 per day. The violation was observed, this picture was taken, and the property was cited.
So my question is this picture from a citation that happened before the citations that we're here about today?
If I may, you're asking whether this was from, regarding an earlier citation?
Correct.
I think she answered the question.
Okay.
She
Yes.
said, it's from an earlier citation. That-
No, this picture right here was when, yes, this picture was when the case initially was started,
Correct,
from the previous violation.
correct. On the
Then-
same property for the same
Correct.
property.
Yes.
My point was this isn't part of a new violation. This is background of a previous violation that had been cited. Is that right?
And in that order, when that order was issued, it is for the violation of outdoor display and sales.
Objection to responsiveness of the answer. I'm really just trying to get to the point of this picture. I'm not asking for an interpretation of the prior
And
order.
I believe she stated that this isn't a regular court hearing, this is a special magistrate hearing.
So it's my understanding, and maybe we can cut to the chase here.
Yes.
The prior order and the city law and the state law both allow that if there are successive violations for the same, in response to the same violation, that's considered a subsequent violation. And therefore it is relevant to this hearing because there was a prior violation for the same, there was a prior hearing and order on the same violation.
Now,
So I'm not-
what I will say is, since you received the amended violation, the property has been in compliance. So, and I stated that as well for my July picture. So if you're asking if this picture is from the previous citation that was issued, yes, it is. But since then, the property has been in compliance, with what the new section 34.342 B, C, and D states. So the violation no longer exists. So no other pictures were taken showing that you were in violation under 34-342 B, C, and D. You are now in compliance. But these pictures are showing the previous violations of why we are here today. This is a continuance. This is not a new hearing showing old pictures. This has been a continuance since the amended violation was asked.
I'm going to object on the grounds of relevance. I'm going to object on the grounds of hearsay. I'm going to object on the grounds.
What is the hearsay?
You're,
These are my pictures.
I'm raising the objections. My understanding is,
No, be very clear.
Yeah,
Sure.
Please.
Oh,
What are
I-
your objections?
my objection is that her testimony about what the order says and means from the prior citation is irrelevant, and it's hearsay, and it's not best evidence.
And it's
So-
not what?
Best evidence.
And,
So I would like to be able to note those objections, and I would like
Okay, and please explain violation, the objections then, so that I will understand what your objections
interpretation, Ms. Beavers, with all due respect, Ms. Beavers' summary interpretation of what an order that is of record with the court says is irrelevant, and should be excluded. Her opinion of what it says, her summary of what it says is irrelevant and should be excluded. It is also hearsay. She's not presenting the document. The document has already been presented in a prior hearing, but she's not presenting it now. She's talking about her memory of the
Why
prior.
do you say she's not presenting it since it's on the screen and part of the record?
That's a picture. Is the order on the screen part of the record? I'm sorry, she's interpreting the order from a prior hearing that happened in 2023.
I heard that objection. I'm talking now about the hearsay, that you're saying that, you're saying that these pictures, you just stated that these pictures are not part of the evidence today. And, why do you say that?
I don't think that I said that the pictures are not part of the evidence today. I was talking about the order that she keeps referring back to and the testimony that she keeps giving about what the order means and what the law is, and her summaries and opinions about those sorts of things are all objectionable, irrelevant, and hearsay.
So all
So
of
I'm
it is,
trying.
all of this is, all of those three objections are based upon the order, not the photographs that are in evidence today, but simply the order itself.
It's based on the testimony that she's giving other than the evidence that she's putting forth, which my understanding is, and I'm trying to follow the process. We've kind of made an opening statement each side. She's presented some evidence. My understanding is the evidence that she's presented is these photographs. In the context of presenting the photographs as evidence, she has also made lots of statements about what happened in a prior proceeding and those sorts of things. So I'm objecting to everything other than the photographs at this time, and then I would like to ask her about the photographs. The point of my question about the photographs, or a point of my question about the photographs, and I don't want to be limiting, is I want to understand, to the extent we're here about violations that allegedly occurred since the 2023 hearing. This previous hearing happened in, I think it was November 2023, I might be wrong about the month, but it happened in 2023. Since then, she has some photographs that I believe started in May of 2024 that are the subject of the alleged violation that we're here about today. I understand from what we just discussed that this picture of not this picture, I'm sorry, of the picture she showed, if you would back it up to the 2023 picture.
This is May. This is 21, September of 23. So,
Correct.
okay. So what you're saying is,
Can
I'm
I
bringing
finish?
pictures,
But Ms.
from-
Beavers,
okay,
he has the floor.
because May shows up.
Ms. Beavers,
Okay.
he has the floor. You'll get your turn.
Thank you very much, Your Honor.
Uh,
I'm trying to do it not in a fashion where we're having a combative conversation. I'm trying to do my presentation, ask the questions that I want to ask, and then once everyone has presented their evidence, we'll present argument and be done as quickly as possible here. But I'm just trying to sort of follow that process. So she presented these photographs, and I wanted to ask her about the photographs. My first question was about the 2023 photograph. If you could put it back to the 2023 photograph, Ms. Beavers. I want to get clarity for the record. To the extent we're here for anything other than a single day violation that is being alleged, that this is not part of the violations that are currently being alleged, but this September 21, 2023 photograph is being introduced to show that there had been a prior violation that has already been addressed by the court. Is that correct?
This picture shows when the property was originally cited for the violation. Once that violation occurred again, which brings us to
Your Honor, this
this
is the opposite
picture.
of my question. And I'm
Sure.
trying.
I don't understand what you're asking, because you're talking in circles. So we're gonna be here for another 2 hours because we don't understand what you're asking. You
Okay.
keep asking me about this picture.
I think my question is quite clear. It's a very simple question. It's really a
This
yes
is
or
where
no.
the case started.
Okay, I'm sorry, we're not gonna do this. Okay, Ms. Beaver, sit down. Mr. Poe, please, I'm sorry, please.
I'm
It's
doing
my
my best to answer
understanding,
that.
it's my understanding that if you would, I believe I understand your question. And I believe that it's my understanding that it was part and parcel of this hearing because it did show it was used in a prior hearing regarding the same property, regarding a similar issue with the outdoor display of merchandise. Ms. Beavers, if you would, is that correct, the way that I've described it?
Correct.
Okay, thank you.
Thank you very much for putting it that way, and that's really what I'm trying to get to. I'm actually trying to craft my questions carefully so that she can answer a yes or no or correct. Of course, she's free to explain after doing so, but I'm.
It will be up to me.
Of
I
course.
will decide what she's.
Of course. Okay, granted. But I'm trying to craft my questions in a way that the answer is fairly simple. And the point of the question is, that's not the subject of a violation today. It's the subject of an alleged violation that has already been addressed by the court. That's what I'm trying to clarify for the record. And is that correct?
I think the question's been asked and answered.
Okay, so it is correct. Thank you. Is this the next picture after the 2021 picture, Ms. Beavers?
Could you identify the picture?
The picture that's on this-
record.
The picture that's on the screen as Exhibit B shows some chairs on the front stoop of the subject property immediately outside the front door. Is that correct?
I think the pictures, excuse me, Mr. Powell, I think the pictures describe what it is well, talking about, the best evidence. I think they describe exactly what it is. She's already testified that these pictures showed chairs and other merchandise outside the front door of T. Gregory. I'm confused by why you are asking that question again.
If there's an objection to my question, I'm happy to try to explain it, but I think I'm free to ask questions in cross-examination that go to what I believe are relevant points. If I must explain the point of my question, these chairs are on the private property, they're not on public property. I guess I could ask that question also, but that would be my next question.
That's a different question.
Yes.
That I understand why you'd be asking that.
Ms. Beavers, do you have any reason to believe that the chairs that are shown on the picture of Exhibit B are on any property other than the private subject property, or that they're on? Yes or no? And you're free to explain.
The chairs that are posted are chairs that are listed on the private property of 1121 3rd Street North, located at T. Gregory Imports.
Let's go on to Exhibit C, please. Can we go on to Exhibit D?
Excuse me, was there anything in regards to Exhibit C?
I would ask if there is. She flipped through the questions very quickly, so I wanted you to go through them and make sure that I know what exhibit A, B, C, and D are. So if I have a question about it, I will ask. Is that okay?
You're just asking her to show the.
Yes. Yes, and if I have a question about the picture, I will ask.
So you had no questions about the photos in
Not at this
Exhibit
time.
C?
Not at this time. Can you flip to exhibit E, please? Exhibit B. Is it your contention, Ms. Beavers, that there is a violation shown in exhibit E?
No, as prior stated, Exhibit E shows that the property is now in compliance and has been in compliance since Exhibit E was taken.
I believe the prior testimony was that it had been in compliance since the last hearing, which was on June 26th. So that's why I wanted to clarify the purpose of this picture. Is this picture being presented to show a violation or not? I believe her answer is no. Is that correct?
It is showing it is in compliance, so no violation is
And what was the date?
June
7th?
25th, 2024.
Those are dated, the photographs are dated what date?
June 7th was just showing the notice of hearing. June 25th is showing that the property was in compliance.
Okay, so the June 7th just shows the posting of the notice.
Correct.
And was that notice for, which violation?
Which violation?
Shown in the June 7th photo.
The June 7th one was for the previous one. It was hand delivered, for the June 20, it was hand delivered in June, that
Okay.
date.
And then the, photograph on the left is dated June
25th,
25th.
yes. That was before the June 26th hearing.
And that shows that there's no violation as of June 25th.
Correct. July 15th, and yes, July 15th is when the notice of hearing was given for this sent certified mail and delivered to the property.
Okay, so on June 25th, there was no violation.
There was no violation. And no violation has been since that date.
And I think
And when, excuse me, when there was no violation, there was no violation of the outdoor display
Correct.
of, okay. Outdoor display. And then, okay, at this point,
They've been in
coming back to you,
compliance.
Mr. Poe.
I can ask,
Okay, now, do you have any other questions about Exhibit E?
so I can explain where I'm going with this, and maybe this will make a little bit more sense. My recollection might be off. I do not recall from the prior hearings that I've attended in June and May of this year, the photographs that were related to May 2nd. I don't think those were shown before. I think it was only May 7th. So what I'm trying to do and what I would like to do in a very clear way on the record is confirm each of the dates that we are talking about that are the subject of alleged violation now. From what I've seen, she has shown a picture from September 21, 2023, which was related to a citation that has been addressed by the court, and it's only being presented to show that there had been a prior violation. That's my understanding. And then there's a photograph, or maybe two photographs, from May 2nd. And then one or two photographs from May 22nd, was it May 22nd? I believe,
They're on for
based
May
on
2nd.
you're off on May 2nd?
We do have the prior special magistrate hearings PowerPoints, if you want to see if any other, if these,
Wait,
And-
please.
and
Could we just say, what are the dates of the Exhibit C photos, please?
May 2nd, 2024.
Both of them?
Yes,
And the same is true for the exhibit, two photos in Exhibit B are also both May 2nd?
Correct.
Okay. So, does that clarify for Exhibit B and C, the dates? Do you want to go to Exhibit B, Mr. Poe? Or did you want to ask about C?
What I'm trying to do is draw a circle around the evidence that's being presented and to know which dates we're talking about very clearly. My understanding is let's go to Exhibit D then and see what the date is, to be clear. Okay, so on Exhibit D, there's a photograph that is May 2nd again, and then on the right, there's a photograph that appears to be dated May 22nd.
It's
Is
May
that correct?
22nd. That is May 22nd, correct. The one on May 2nd, you can see there's a chair in the background. Underneath the flag, you'll see there's a chair. On May 22nd, there was no chairs present.
So, and then E does not show a violation. So the violations that we are here about, the alleged violations that we are here about, is this correct, Ms. Beavers, are shown by Exhibit C and D.
Correct.
And that is the totality of the evidence that you're presenting today
Could
as,
I, for clarity, what about which ones? B, C, and D? Does it include B, Mr. Powell?
let's go back to B and C. I suppose it does. Is that, it's up to Ms. Beavers. Are B, C, and D, your exhibits, B, C, and D, the evidence of violations that you're presenting here today? I think that's the clearest way I can ask that question.
Correct.
That's the totality of the evidence. Okay. I think that's it. You've answered that question. B, C, and D exhibits are the evidence of the violation that you're alleging here today. All right.
Mr. Poe, I would also say that her testimony is also evidence that she's presented in her presentation.
Correct.
And-
To the extent that she has testified about what the law is, I object to that on the grounds of relevance. To the extent she testified about what documents say that aren't being presented, that aren't presented to us here, or that were written by somebody else, I object to as hearsay and irrelevant. So,
The state,
My-
city ordinances. Here's that.
Okay, he has a right to object. There's no need to.
No, I was just trying to get an understanding. He said, I'm stating something that was written by somebody else. Is he referring to the ordinance that was written by somebody else? Because I didn't write the ordinance. I'm here to enforce the ordinance.
I think that he's referring to the order.
Okay.
well, and also her summary of what the ordinance may or may not say, to the extent she's summarized.
Yeah, that's what I thought he was referring to, me stating about the ordinance.
Right, thank you, I understand. It's the order that he's referring to.
The order and the law speak for themselves. And so I'm saying to the extent
Okay, go,
she has
please.
summarized those things,
I understand.
that's the subject of the objection. Is there any other evidence to present?
No, sir.
So I take it that the city of Jacksonville Beach has presented all the evidence they have to present on the issue. Is there any other evidence to present?
No, sir.
Okay. So I take it that the city of Jacksonville Beach has presented all the evidence they have to present on the issue. Is there any other evidence to present? Okay. So I take it that the city of Jacksonville Beach has presented all the evidence they have to present on the issue. It's my turn to present evidence, is that correct?
Well, I do believe that this is a continuing hearing, so the evidence that's been presented in the past is part and parcel of the whole package.
The hearing that started in May of this year, is that correct?
Yes, this has been a continuance.
Right, this is the third, basically the three-part series that we're doing. We came in May, we came in June, and now we're here today. I understand that this is a continued matter as part of these three hearings. This is the third. Understood. And so I'm trying to be clear that we're wrapping up the presentation of evidence at this point, mindful of what's been presented at other hearings. Since in May 2024 and June 2024, and now this being the third hearing at issue.
That's my understanding.
Thank you. So if the city has presented all their evidence, it's my turn to present evidence, and you said that the city will have an opportunity to rebut if I present evidence that they wish to rebut. Is that correct?
I believe that would be appropriate.
I have no further evidence to present, which means I assume there's no rebuttal. So evidence is concluded and we can make legal arguments. Is that correct?
Does that mean that the remainder of your presentation is going to be argument?
Correct.
I think that you would be able to respond to your argument also.
With evidence?
Well, her testimony is evident.
So my understanding of the process, and if it's different here, you can explain it to me, is we've made essentially opening statements, we've presented evidence, evidence is closed, and now we make arguments about the evidence in a conclusory way. If we open the evidence back up, then that just turns into a Mobius ring. So I'm trying to tie a ring around the evidence.
I understand
So that
what
I
you're
can
trying to do,
make
but I'm
arguments.
going to allow the hearing to be a fair hearing, and if there is something that Ms. Beavers think is appropriate for her to respond to, I'm going to let her do that. If you feel like there's something that further that you end up wanting to respond to, I'm going to let you do that too. So, tying a ring around the evidence is, probably more than what we actually have to do at this stage. At the end of the hearing, then that will obviously be the end of any evidence. But I don't think that we have to be so technical here and force a situation that, she can't talk about that because that constitutes evidence. I don't think that's appropriate for this level special magistrate hearing where we have a violation, an alleged violation of city code. So,
I appreciate that, and respectfully I disagree. I'm just trying to avoid the back and forth banter that has plagued prior hearings and trying to just sort of have a process to it. But if that's how you'd like to do it, Judge, it is your prerogative. And then I think it is Ms. Beaver's turn to make a concluding argument if she wishes to. And then I will take my turn.
no, it's your turn. This is your turn. Ms. Beavers can have a rebuttal if she wishes. I've already told you that you can speak again, but I think it's appropriate, for you to go forth and present your argument at this time.
Your Honor, she's the plaintiff, and it's their burden of proof. And my argument is they have not proved that there's a violation. And I can go into the details of that, but
You haven't said why. You just objected on the basis of to one photograph from September of 23. You've objected to that, but I haven't heard any objection to B, C, and D. I haven't heard any argument why now you just said you don't think there's a violation. I've heard no testimony from you as to why.
it doesn't need evidentiary testimony. It's literally legal argument on the face of the law. Again, and I'll make the argument, Your Honor. Here we are again, quite frankly, with the city arguing that there's been a violation of ordinances that are not applicable to the facts at hand.
She said that you are in compliance,
Mhm.
that you've been in compliance since, I wrote down June 26th. Now, that might not be accurate, but that you've been in compliance, and that her recommendation, let me see what, if I wrote down. Actually, I don't think I wrote down the recommendation. Ms. Beavers, was there a recommendation?
Yes, it was the,
I apologize.
Oh,
I'm
no
trying
problem.
to keep up with the notes.
my recommendation was that the case was in compliance and that the, property owner remain in compliance. Any further, violations would be a $250 per day fine.
So is my understanding that no fine is being sought at this time?
Excuse me. Yes, actually, that's exactly where I was going, Mr. Tubb. That the property's in compliance now.
Under the new violation,
Right, that the
And-
property remain in compliance, and that the property would be subject in the future if there was another violation of the same,
correct,
or the same violation in the future, that would be subject to,
a fine, a daily fine of $250 per day.
and what about, now, is the city recommending any fine to be, placed against T. Gregory at this time?
No, now that it has been cited under the correct violation, there has not been any further violations that occurred under, since the, ordinance was correctly cited.
Okay, and, no fines to be assessed. Thank you very much for clarifying that. Okay, Mr. Poe.
And for me to, I'll explain why. Well, let me say this first. I do appreciate that the city is not seeking a fine. That's appreciated, and I don't want that to go unnoticed. But again, like the first hearing, it is our position that there should not be a finding of a violation. So there's this assumption that there's for there to now be compliance, there's an assumption that there's been a violation, and our position is, again, there has not been a violation. And the evidence presented by the city does not show a violation of the ordinance that are cited in the notice. So while I do very much appreciate that the city's not seeking a fine, they do seem to be seeking an order indicating there was a violation and that affects future conduct to remain in compliance and not violate. But there has not been a violation of 34-342 B, C, or D. Those are
Since,
the evidence presented does not show a violation of 34-342 B, C, or D, which is the ordinances noticed in the notice. So, to back up, and I'll try my best to be
so,
succinct.
maybe I can cut to the chase here for you. You're saying that because the amended notice was dated July, whatever, what was the date of the amended notice?
The amended notice was, given on July 15th.
July 15th. Do you agree that the date is July 15th, Mr. Powell?
The notice of hearing is dated July 15, 2024. That's the
Okay.
date that it appears to have been written.
And I also have returned unsigned notice here as well, that was sent certified mail.
Okay, thank you. So, back to what I think, and you can correct me if should not, or I should not agree with the city's recommendation to find that, that the photos taken in May are, outside or were taken before, and therefore not relevant to the current notice of violation. Is that correct?
Well, I agree that is correct, but that is not what I was about to say.
Okay, go ahead.
So I agree that is also a reason that the court should dismiss the case without finding a violation. But what I was about to say is, if you read, this is much more like the very first hearing when they cited for a violation of the business of outdoor advertising, and it became very clear that the ordinance, the business of outdoor advertising prohibition, was not applicable and was not violated. Likewise, 34, 342, B, C, and D have not been violated at all by anything we've been shown here today.
Ever? Not in, not, you don't
I can
believe,
only-
let me ask very clearly, you don't believe that the pictures show outdoor storage? The pictures taken in May show outdoor display and merchandise?
So if I could, I don't believe that the statute speaks to outdoor display of merchandise. Again, it's very much like the first time.
No.
The statute's not applicable. Can I, if I could
It is applicable.
answer,
It is applicable.
can I explain why I believe that it's not?
Sure.
Thank you. This statute, 34, 342, talks about uses of the property. And it goes on to say that there are permitted uses, which is B, and then C concerns accessory uses, and D concerns conditional uses. Let's look at B. B talks about 1, business and professional offices, 2, bakeries and manufacturing, 3, jewelry and leather. Let's go down to 6, retail trade establishments as follows: building materials, hardware and garden, blah, 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 home furniture, miscellaneous retail. T. Gregory Imports is and always has been in compliance with 34, 342, B6. It is a permitted use under this ordinance to have a retail furniture store. This ordinance, 34, 342, does not talk about, that I see anywhere, particularly not in B, C, or D, merchandising, marketing, signage, or any of that. Rather, it says you can have a store that sells optical goods. You can have a place of business that is a travel agency. You can have a restaurant. It doesn't say whether or not what the travel agency can do for merchandising of its business. It doesn't say what the travel agency can do with displays of its merchandise. It doesn't say what the travel agency may or may not do for advertising or signage. It says what kinds of businesses are permitted uses on the property. That's what this ordinance is about. So to extrapolate that into, to try to make this an ordinance that is talking about signage and where you can put chairs on your property is completely not correct. So then we go to, so we see that T. Gregory Imports is a permitted use under 34, 342, B6. It is a retail furniture store, clearly within the permitted use provisions of that statute. And then we go over to C, which is the next thing they said it's a violation of. And that's accessory uses. And it says that it permits any use customarily accessory to the permitted and conditional uses, which means C looks back at B. If you're a permitted use under B, which T. Gregory Imports clearly is a permitted use at B6, then you also can do whatever, you can use the property in a way that is customary, which is any use customarily accessory to that permitted use. So, one, I believe, and our position is that the placement of merchandise in or outside the store, and signage, and flags, and everything else we'll hear about, is not addressed at all by B, C, or D. But if it were, then C says that if you've got a permitted use, like a retail furniture store, then you can do the things that are customarily accessory to that, like placing your merchandise to invite people in, or having an open sign, or having things of that nature. So it's either not applicable, or it further clarifies that what T. Gregory is doing is permitted under the statute. Now let's go to D. D is conditional uses, and that lists out other kinds of businesses that were not included in B, permitted uses, because D, conditional uses, requires that you check the box on some conditions before you can get allowance to do these things, like a packaged liquor store, or a camps and recreational vehicle parks, or a car wash, or a funeral home, or a drive-in motion picture theater. We're not doing any of the things listed on D because we're clearly a permitted use as shown by B6. So D is plainly not applicable. C is not applicable in my opinion, but to the extent it is, it just says that if you have a permitted use under B, then you can do the stuff that's customarily accessory to that, which is all T. Gregory is doing. So there is no violation of B. In fact, the evidence shows, the only evidence that has been presented to the court shows that T. Gregory Imports is in compliance. The property is in compliance with 34342B because it's a permitted use, a retail furniture store. There's no violation of C, and there's no violation of D, and that's what we're here about. And here's another point I would point out, is to the extent they try to argue that signs and that sort of merchandising is somehow included in B, which we can, there's no reason to read into the record because it's a matter of law.
What sign?
If there's a contention that a sign or a flag or a chair is somehow...
Are we talking about signs or are we talking about chairs? What are you, do you raise the sign? I've heard notice of violation regarding the sign.
Okay.
So...
I'll try to finish making my point then, and hopefully it'll be clear. My point is this. My point is, B talks about various uses in terms of kinds of businesses that can be on the property. C says certain customarily accessory uses are permitted. D has conditional uses of other kinds of businesses that require some hoops to jump through in order to have that business there. And then if you flip down to I talks about signage. And my point there is things like signage and merchandising and whatever else are not intended. One, they are clearly not on the face of it addressed by B, C, or D, and they're not intended to be addressed by B, C, or D. B and D talks about the kinds of businesses. Can it be a Jiffy store? Can it be a drive-through restaurant? Can it be a pharmacy? Can it be a retail furniture store? The answer is yes. It's a permitted use. Chairs or a flag on the property is not addressed by these ordinances. That is the basis of the violation now. So just like we were back in May, my argument is the city is trying to issue citations for something that they don't have a foundation in the law to issue a citation for. And I understand their plight. I do. They're operating under decades-old ordinances that probably need a refresh to be caught up with the times. And they're trying to figure out a way to make things work the way they want them to work, but that's not the way the process needs to go. They have to actually adopt laws that do what they want in order to enforce those laws. They still haven't cited the law that's being violated here. And we can't just interpret that into being based on ordinances that are clearly not applicable. And I also understand their struggle because, frankly, what they're trying to do is anti-business. So it would probably be pretty difficult to get the ordinances that they wish existed actually adopted. But there's not an ordinance that says you can't do what they're saying T. Gregory has done as a violation. And so while, again, I'm very appreciative that the city is saying that they're not asking for a fine, we disagree with the underlying proposition that there's been a violation of these ordinances at all for the court to then order that there must be compliance. T. Gregory Imports is and already always has been, as far as I know, and as far as any evidence presented that I've seen, is in compliance with 34-342 and hasn't violated it. So that's the crux of my argument on that.
If I may, I'm going to ask you about the provision that is also included in the notice of violation, which is 34-3116. How do you account for your argument is that you've addressed 3042 B, C, and D. How do you, what is your argument about 34-3116?
As I read this, it doesn't appear to be alleging a violation of 34-3116. Rather, I think it's being cited as some sort of authority to broadly interpret 34, 30, what 16 says, and I can read it to you. I don't know if you have it.
As you read what?
As I read the notice and as I read the statute itself. I can't tell you what anybody's thinking other than myself, but I'm looking at the notice. I did not read the notice as alleging a violation of 34-3116. Rather, I thought that was some reason they were citing that as some sort of enabling. But maybe I'm wrong about that. I don't know. But all it says is this. It says at 16, exclusivity of uses in zoning districts. The permitted uses and conditional uses in the zoning districts established by Article 7 zoning districts are exclusive and shall be permitted subject to the standards and procedures of the LDC. Right? So, okay. That basically says that B, C, and D that we talked about, the permitted and conditional uses, are the exclusive uses. Right. If it's not a medical dental laboratory, a child daycare, a travel agency, a retail furniture business, then it's not among the permitted uses. But our store is among the permitted uses. And that's, use is referring to kind of business. It's not referring to how you merchandise. There's nothing to suggest that that's what use means. It's just not there.
So you're saying that you don't think the description of outdoor, let me get this right, you don't believe that outside sales and display of merchandise is a use?
Where are you
Is that what
looking
you're
at that?
saying?
Where are you talking about outdoor sales and outdoor merchandise? Is that in the ordinance?
That's in the notice of violation.
Correct. That is correct. I do not think that's the kind of use they're talking about. That's if anything, if it's applicable at all, it would be under C. But I don't think it's applicable at all because this is talking about the kinds of businesses. Use is referring to the kinds of business. Not anywhere does it talk about what a travel agency may or may not do on the property. Not anywhere does it talk about what a jewelry store may or may not do on the property. And not anywhere does it talk about what a retail furniture store may or may not do on the property. It doesn't go there because it's completely not applicable.
You don't think, again, are you saying you don't think it's a use?
No, I do not think it is a use of the property as being addressed by these ordinances. That is correct. And then we circle back to the business of outdoor advertising, which is what the original violation was. And
we don't really need to talk about that at this point.
my point was, perhaps you could argue that that would be a use, but we've already determined that's not applicable. The city's trying to make this ordinance do something that it is clearly not written to do. And they don't have an ordinance that's applicable, so they're trying to say, well, we have really broad authority, so we can say it says that anyway. But that's not consistent at all with the state of the law, and if they want a law that says that that retail stores can't merchandise certain ways, then that's something that they should adopt as a law in writing that people will be on notice of. This does not give that notice in any way whatsoever.
Okay, is there anything else?
I reserve my right to rebut, I suppose.
Is there anything else at this point in time?
Not at this time, no.
Ms. Beavers, could you tell me whether your testimony is that outside sales and display of merchandise constitutes a use under the Jacksonville Beach Land Development Code?
As it states, the use of outside sales and display of merchandise. That is listed under 342, B, C, and D. If it's not listed, it is not a permitted use. The code is interpreted by the Director of Planning and Zoning, and that is her interpretation along with what the ordinance states.
And therefore, the outside sales and display of merchandise constitutes a use as far as the city is, that's the position of the city.
Correct. As shown in the pictures, there are, and I don't know if you can, where's the light, where I can circle? Okay, right here, you can barely see it, but there's a price tag that's right there. And then also on this one, it's showing that this chair is being sold as is. So these are not just chairs that are being set out. They actually are merchandise that are being displayed for sale.
Okay, thank you. Go ahead, Mr.
I think there's a point of clarification that
I think there's a point of clarification that might clear something up, because she was reading from the notice of hearing. May I ask you something, Ms. Beavers? You were reading from the notice of hearing, and you read the use of outside sales and display of merchandise is not listed. Do you understand that that sentence in the notice of hearing is not part of the ordinance?
This was taken from the city ordinance, City of Jacksonville Beach ordinance.
This
So
notice
if it is not a listed use, that means it is not permitted.
This ordinance gives a citation of 34342 B, C, and D, and then it puts quotes, permitted accessory and conditional uses, which is essentially what that provision is about. But then that next sentence is this notice's summary of the law. That sentence does not appear in the law anywhere.
But it states it is not
Correct.
a use that is listed, so that means it's not permitted.
I understand that's what the notice is saying, but
And
what,
that is the interpretation that came from the planning and zoning director,
I'm going to
who interprets the code.
I'll address that in just a second. But I'm going to be very careful, because I know that it's kind of prolonged things for us to step on each other's words. I will not interrupt you. Let's try to just take turns talking. My question is, do you understand that that sentence that you're reading as if it's part of part of the code is not part of the code? That is just a summary statement in this notice of of legal analysis of whoever wrote this thing, but it is not the code. You follow me?
I
can show
clearly
you.
just said the director is the one who interprets in the use of outside sales and display of merchandise is not listed in all those things that you stated was listed in there. It's not listed. So if it's not listed, that means it's not permitted.
And so my
Objection to that?
Okay, so my objection to that is, and again, with all due respect, Ms. Beaver's summary and or opinions of what the law says is not relevant. To the extent she's saying that the director
Who
of
interprets
plan,
the code.
to the extent she's saying that the planning and development director has interpreted the code, that's hearsay. The planning and development director is not here to testify about that, and I object to this being continued yet again for such a purpose.
We won't be continuing the hearing.
Okay, so can I?
I'm going to say that the addition of that language, the sentence, the use of outside sales and display of merchandise is not a listed use in the C1 zoning district, is simply an explanation in the notice so that you, the recipient, will understand what the violation is. It's an explanation. It doesn't need to be included in the verbatim language. It's an explanation of what why you're receiving the notice of violation.
I understand that, Your Honor.
I think this whole discussion that you've raised about is it or is it not part of the land development code, that sentence is simply an explanation. And that's the way that I read it, and that's the way that I'm going to rule on it.
So I agree with that, except for I would like to make this point, is that nothing in the cited code sections talks about the use of outside sales and display merchandise.
Nothing where?
That's
Say that again?
nothing in 342, I'm sorry, in 34, 342B or C or D talks about the use of outside sales and display of merchandise. It doesn't address those.
I believe that that's precisely the point and the position of the city, that it's not listed anywhere. And therefore, pursuant to 34-3116, it's a violation in C1 zoning district to allow to have the use of outside sales and display of merchandise. That's a use.
Respectfully, I suppose I see where you're going with this, but I disagree that that's a use. The uses that are laid out are types of businesses. And we've already talked at length about how outside advertising is not the business of Tigger Gregory Imports. That's not its business. That's why K wasn't applicable, because it's not in the business of outdoor advertising. It's a retail furniture store. So it is in compliance with 6. And I will also say that the statements about what the planning and development director's opinions are and interpretations are hearsay. And if he's issued an interpretation or rendered an interpretation on this issue, we don't have that before us.
Is there anything else?
Can I add to my recommendation for the 10 permits that will allow?
Let's see if he's got, let him finish, please.
How about I look at my notes while she says what she has to say, and if I have something else, I'll let you know. Is that okay, Your Honor?
Yes.
Thank you.
I would like to add, to include in my recommendation, if T. Gregory wants to have outdoor sales, they can apply 6 times a year for 3 days each time for a tent permit, and that's at the planning and zoning department. That's the only time that the city will allow any type of outdoor sales and display.
Is that the same as the seasonal sales?
No, that is not the same.
Are seasonal sales allowed in this district?
It is, but that's for like Christmas trees, pumpkins, those types of things, firewood.
Would it be possible to have seasonal sales in C1 that for this type of use?
Not that I'm aware of. The only time is when they apply, when a company or business applies for the tent permit.
Okay. And is there a reference to the code regarding the tent permit?
Yes, I don't have it directly in front of me right now in regards to,
Could you find that before we conclude today?
Yeah.
Okay, thank you. Anything else?
So for example, Your Honor, we sell armoires, we sell, other sorts of accessories that go with furniture. This code doesn't talk about those kinds of uses, whether you're allowed to sell chairs as a retail furniture store, or beds as a retail furniture store, or outdoor furniture or indoor furniture. It doesn't go into, it says that the use allowed, permitted, is a retail furniture store. It doesn't talk about, I've made this point, I guess I'm being redundant, it doesn't talk about what jewelry stores can or cannot do with their merchandising. That's not the kind of use that this is addressing. So I fully understand that the city's trying to make this work where it doesn't, but it is not an applicable ordinance, and there isn't an applicable ordinance that I'm aware of, which is why we're back here for a third time.
If you don't think it's a use, what do you think it is?
It is part and parcel of the business of retail furniture store, being merchandising.
It's what?
Merchandising, I suppose, inviting the public as customers to come into the store, making people aware that you're open. Those are all things that every one of these businesses are permitted to do, even though it doesn't say so.
What are those things that, I mean, how do you classify that?
Just like they have with the signs. If they wanted to have an ordinance that addressed,
No, I don't want, I'm asking you a very specific question
I don't think,
about the outdoor sales and display of merchandise.
and I'm
If
being
you
very
don't think that's
specific,
a
and I should be
use,
permitted to answer the
what-
question. I'll answer the question.
I'm
It's like-
I'm asking the question.
I'm trying to answer it. Yes, Your Honor.
If you have said you don't think it's a use.
Uh,
What do you think it is?
Just like I don't think having a sign is a use of the property. The ordinances address signage separately, because signage is marketing or displays ancillary to the permitted business use at most, right? So they could have, just like they have sign ordinances that say this is the kind of signs you can have, and this is the kind of signs you can't have, and this is how big the signs can be. If they wanted to enact an ordinance that addressed outdoor, having some merchandise outside, then they could have an ordinance that addresses that as well. They don't have that ordinance, so they're trying to say this ordinance somehow encapsulates that, but it clearly does not. It's not talking about that sort of a use. To the extent you're trying to say advertising outdoors is a use, they've addressed that with what we talked about before, which was the initial, I guess it was 342K, the business of outdoor advertising. And they said you can't do that. They said you can't do the business of outdoor advertising, but as we discussed, when we showed that that ordinance was not applicable, that the legislative intent behind it was so that local businesses could advertise their own business without being cluttered up by billboards from third-party advertisers. So they can address it separately. They have addressed it separately. They have not addressed whether or not stores can have a chair outside, and it's not wrapped up into this kind of a use. It's separate, like signs, and like outdoor advertising, which they've addressed by separate ordinances.
You still haven't answered my question.
I believe I have, but I'll try better if you let me know what you think I'm missing.
What do you think it is if it's not a use?
Use in this context context is talking about the kinds of properties. It's just like we have restrooms. Is having a restroom at the store a use? Does that need to be defined in 342B? It's not applicable. We have a point of sale. We have a cash register. We have shelves. We have lots of things. We receive and deliver shipments of furniture. That's also not listed here. Are those, by that broad definition of use, you could extrapolate.
How do you classify those?
I don't think it's incumbent upon me to figure out how to classify
I'm
them.
asking you.
I don't.
If you're the one who's saying it's not a use, then what is it?
I think I've basically answered. It's part and parcel of the type of business that is permitted. So you have permitted businesses like a jewelry store, and they can sell jewelry, and they can have a cash register, and they can have signs that advertise that they're selling jewelry. And if it's a sign, now you got to look to the sign ordinance, because the city has actually addressed
You
signs.
answered my question. Okay. You wanted, is there anything else, Mr. Sullivan?
And you were asking me questions, so I didn't.
I don't have any further questions for you.
Okay, thank you.
Your Honor, can I, what about you with this?
Ms. Beavers, could you please tell me if you were able to find a code provision for the tent sales?
They did not bring me the code provision, but this is the, City of Jacksonville Beach private commercial event policy.
Okay.
So there's some relevance. What is this? I don't understand what this has to do with the citation that we're here about, Your Honor. I object to non-relevance.
That's part of my recommendation in regards to allowing the outdoor sales.
Is it allowing outdoor sales pursuant to some other ordinances that are already available to every other business?
I'm sorry, I'm reading something at the moment. Okay, I'm looking at some documents. I'll entertain your further comments in a moment.
I was just trying to refer for the objection. I thought it was time to do so.
So, just for clarity, Ms. Beavers, you've given me the City of Jacksonville private commercial event policy. It was established in November of 2023, and it says that the purpose of the policies outline the guidelines to hold events at privately owned commercial properties. And it talks about events may be approved up to 6 times per calendar year for no more than 3 days per event. Goes on to talk about other items.
Yeah, so the tent permit that you see listed on there is where for tent sales, like special sales, events, football games, and a business wants to display and bring their merchandise outside, they would apply for the tent permit for that use.
Okay, it's a policy, it's not set forth in the ordinance code?
From my understanding.
Okay. And, do you have another copy of this?
No, but I can get
Okay.
them a copy.
I'm gonna hand this back to you. I'd like you to end up making it a part of the record.
Okay.
And I'd like for you to provide it to, this copy to Mr. Poe, to allow him to review it, and then if he's got some objections to it, he can let me know. Thank you.
May I ask what the relevance of this document is, or the relevance of the
The relevance, my understanding is that the relevance is that the city has requested that it be made part and parcel of the recommendation to me, that it would be part and parcel of the recommendation that this be included in my order on this matter to inform the business that this is an option that's available.
So I object on the grounds of relevance.
Uh,
We're not-
On the grounds of relevance,
On the grounds of relevance, at least, that we're not here about a tent sale.
Susan
application.
copy graphic.
I understand it
Yeah, I-
being offered simply as a city's requesting that I put it into the order
And
as, you know, information, in my order.
I guess I would object and ask that it not be included in the order because I don't see any relevance to this application, of this tent sale application to any of the issues pertinent to
The
this
relevance would be allowing the outdoor sales of your merchandise. That's the relevance.
So, as I understand it from what you have just discussed, this is not part of any ordinance. This is a policy that somebody's come up with, so I'm also going to object to this on the grounds of hearsay. It's a two-page document. I don't know much about where it comes from or if it's complete or if it's official or how it's been adopted. So I object to it on all those bases in terms of, I think the official objection would be lack of foundation and relevance and hearsay. But it actually probably further goes to the point that they've adopted some policy that is not really law, but it's some accommodation that has been put together to bolster the idea that that there's some restriction that really isn't provided for in the ordinances at all. It's not addressed.
Okay, so at this time, I'm going to rule in favor of the city. I will issue an order that finds that that the issue has been, that the violation has been corrected, and that the city, well, that the city, I'm going to issue an order as recommended by the city that finds that you are in compliance, that and that if there are future violations of the same, that there'll be a $250 fine per day. That at this time, no fines will be assessed. And I will take under advisement whether or not to include the policy.
May I ask what form of notice I will receive of a violation?
I'm sorry,
May I ask what form of
Can you-
notice, if there's an alleged violation, how and what?
can you please,
I'm sorry.
are we going to start the whole hearing over again, Mr. Paul?
No, I'm not trying to start the.
Okay, what is your, I've ruled, do you have something to say?
No, Your Honor, I'm fine, thank you.
Thank you. I think that we're done with this particular item. Let's see, we still have, well, actually,
We do have one more case,
We've got
but
one
it's,
more.
May I be excused?
Certainly. I'm sorry, B,
yes,
case number 23-46,
yes,
Mr. Benza.
yes. Laura, what happened? My clicker isn't working. Okay, there we go. All right. number 2346, Joseph Benza, 1023 North 14th Avenue. This case was in reference to a building permit not being obtained at the time that work was being done. A stop work order was issued. The permit is set to expire on, I want to say the 30th, or it has expired. And my recommendation is that the property owner obtain a final inspection and get a certificate of completion.
So in May, I believe, I issued an order. In that order, it said that a permit was issued by the city in September 23,
Yes.
and for the work addressed. However, a certificate of completion had not yet been issued by the city,
Correct.
and that the respondent was to obtain a certificate of completion by today.
Correct.
So, is there any further report about the extent of work that still needs to be completed?
As of today, from the information I got under the building department, the final inspection had not been completed. And so no certificate of completion had been obtained.
Is there still work to be done? Do you know?
I'm not sure. All the work was internal. There was really no external work other than the garage that was removed. And no permit is required for the removal of the garage. It's all internal, so I'm not clear on what else other than the final inspection.
Okay, well.
And that had not been scheduled yet. I would continue it for 30 days to notify the property owner to schedule the final inspection.
Okay, when is the next hearing? Madam Clerk, could you tell us when the next hearing date is?
October 23rd. There's a special hearing, but I can't.
Oh,
The
actually,
30th,
it's
we're
the
doing it at
30th.
the end
That's
of
right.
The 30th, okay.
Is that still acceptable, October 30th?
Yes, yes.
Thank you. I'm just concerned that we are continuing to do this over and over again. I think that, for the next hearing, I would like to see, something from the building department. If the certificate of completion has not been issued, I'd like to understand from the city why it hasn't been.
Okay.
What is happening.
Okay.
Because, I'll give them another till the 30th,
Yes.
but I think past that, leaving this open and, is inappropriate and.
I believe the work is finished. A lot of times with final inspections, contractors will feel like once they finish, they're done and the permit expires. And that's just from my experience, seeing where a lot of final inspections were not completed, but being that this was a stop work order, that's why the city is requesting that the final inspection and certificate of completion is obtained.
You said that the permit has expired?
Yes.
When did it expire? My note says that a permit was issued in September 23, but I
And
don't.
it's good for 180 days.
Okay. Well, it can be longer than that.
Yeah, because they
Or
can't
closer.
extend it.
Let's confirm that the permit has expired.
Okay.
Okay, so you will confirm that the permit has expired. We will bring this back for October the 30th, and the requirement will be for final inspection and certificate of completion to be issued by October 30th.
I'm sorry, were you saying that the hearing was on October 30th?
Is that what we did?
It's October 23rd.
Well, no,
No,
it
remember,
did get changed.
remember we changed it?
Oh.
Because,
It was my.
both of us was gonna be
Oh, okay.
out, I'm gonna
I'm
be the
sorry.
person, I think, yeah,
I'm sorry, I remember now.
yeah.
I think that it went through the proper channels to
Yeah.
make sure that the chambers were available. But you can confirm that again, just to make sure. Okay, great. Thank you. Is there anything else for today?
No, that conclude, I cannot talk today, that concludes all of the cases we have for today.